Excellent. Well, hopefully everybody can hear me. A very, very warm welcome to this Guildhall Commercial and Property Law webinar entitled As the Credits Roll, What We Can Learn from the Case of London Trocadero and Picturehouse Cinemas. We had some fun as to what the title should be. The curtain falling on tenants' arguments came to light, but I think that's been used in an article somewhere. No time to be a tenant was another suggestion, but as the credits roll, it is. As I say, a very warm welcome to you all. My name, many of you won't have seen me before, and I may not have seen you. For those who don't know me, my name is Chris Stoner, and it's my pleasure to present this webinar this morning together with Nicholas Evans. And we are going to jointly discuss really a case analysis of a relatively important decision, we think, called London Trocadero and Picturehouse. And it raises a number of issues, both for property lawyers and also commercial lawyers more generally. The way we're going to deal with matters this morning is I will briefly run through the facts of the case for those of you who aren't aware, so that it gives that factual background for what, as I say, is going to be a case analysis. Then Nicholas will put it into context, this being, to follow on, I suppose, from the cinematic theme, the last in a trilogy of cases where tenants have sought to escape particularly rental liability over the course of the pandemic. I will then pick up on one of the major points in the case, which is an argument about the failure of basis, before Nicholas then deals with the issue of implied terms. If we get an opportunity at the end, and there may well be an opportunity at the end, we'd welcome any questions that you have. Please use the relevant Q&A function on Teams to put forward your questions, and we will do our very best to answer that. So without further ado, I'll move on to the facts of the case. So if I can go on to the first slide, I can whiz through these relatively quickly. You there have the full name of the case. It's a decision of Mr. Robin Voss, sitting as a Deputy High Court Judge from late September of this year. And just to give the cast list at the beginning as opposed to the end, the landlord is Trocadero, London Trocadero 2015 LLP. It has been the landlord since 2015. There were 3 defendants, and all of the defendants are members of the Cineworld group of companies. The tenant and the company referred to as the tenant throughout the judgment, if you refer to that, is Picturehouse Cinemas Limited, so the first defendant, and it is the tenant pursuant to 2 leases, one from 1994 and also one from 2014. And we know from the judgment that in 2014 there was a variation and surrender of part, which explains why there was that the 2 leases. So on to the next slide, we can see that Gallery Cinemas Limited, they were the original tenant. 1994, for the property lawyers amongst you, you will note that's before the Landlord and Tenant Covenants Act of 95. And therefore one is still looking at original tenant liability in its old form. And then Cineworld Cinemas, the third defendant in the case, is the guarantor under both leases. So I've just effectively set out there who is liable for what, but I can pass over that for the purpose of today. So on to the next slide. The 1994 lease was in fact an unusual beast in being a reversionary lease for a term of 35 years, commencing in 2006. We needn't worry too much about that detail. We're not told much in the judgment about it. But the 1994 lease is the important lease. The key covenants are there was a covenant in the usual way to pay rent without any deduction whatsoever. That went primarily to a set-off argument that Nicholas and I are not covering this morning. But despite those wordings, set-off was still available if you're interested in that last aspect of the judgment. There was a covenant to pay additional rent equivalent to the cost of insuring against insured risks in the usual way. Also should highlight there was a covenant to comply with all obligations imposed by any act or acts of Parliament or legislation in respect of the demised premises or the use thereof. Obviously important when one comes to the COVID regulations. These are obviously all covenants by the tenant, and there was a covenant as well not to use the premises other than for the permitted use. And we see the permitted use on the next slide. I won't simply read it all out. It is there for you to observe. It is basically, for those of us who go to the cinema, everything you would expect at the cinema. There might be a nice little chancery point on whether there are actually ticket barriers and therefore whether it cuts in, but I'll stop that pedantry straight away. So just further couple of clauses just to be aware of. There's the usual suspension of rent or service charge where the premises are unfit due to insured risks, the obvious one being fire. And in clause 5.5, there was a provision, not so much a covenant as just a statement by the landlord, or a warranty by the landlord, or statement there's no warranty, I should say, that nothing herein contained or implied, nor any statement or representation made by on behalf of the landlord or superior landlord prior to the date hereof shall be taken to be a covenant, warranty, or representation that the demised premises can lawfully be used for the permitted use. So one of the slightly odd features of this case is that there was lots of argument about, well, they can only use it as a cinema, but the landlord actually at one point says, well, you can only use it as a cinema, but it doesn't say that you have to use it as a cinema. But that warranty does have some importance, so we'll come back to that. Just to move on with the facts, the 2014 lease just imports all the terms of the 94 lease, one of those situations where because there's a surrender and a regrant, not a surrender and a regrant, sorry, a variation, a surrender of part, there's a new lease, and rather than set everything else out, it just imports the provisions from the earlier lease. And I've there set out the COVID regulations. I won't bore you by going through them in detail, but just moving on to the next slide, we get really to the nub of it, where we see that between the 23rd of March last year and the 16th of March this year, sorry, the 16th of May this year, the takings at the Trocadero cinema, which some of you may be familiar with near Piccadilly, near Leicester Square, sorry, were 247,000, and compared to the same period, the last available period before the pandemic, that the takings were 8.92 million. So one can see the imperative behind argument. The rent arrears, we are told, amount to £2.9 million. Moving on to the next slide, there is the history of the case. Effectively, I can summarize it by saying there were amendments. There were one or two arguments we needn't worry about for the purposes of this morning, but there was a claim for unpaid rent in the sum of around £2.9 million after the amendments, and it came on for hearing in July, and that hearing was for a summary judgment application. And one of the defences that was put forward by the defendants, particularly the tenant, was failure of basis. There was also the implied terms argument. So that's a quick précis of the facts of the case. And I'll hand over to Nicholas now to just put this particular case in its proper context.
Thanks, Chris. And as Chris has already highlighted, this is the latest case involving a tenant seeking to, well, somewhat desperately, to avoid its liability for payment of rent as a result of non-use of premises or part non-use of premises resulting from restrictions as a result of COVID-19 and all the lockdowns associated with them. So the first case that was heard, well, the judgment was given earlier this year, is Commerce Real Investment Gesellschaft MBH and TFS Stores Limited. Apologies for butchering that. This judgment was handed down by Chief Master Marsh on the 16th of April earlier this year. The hearing was in fact heard on the 18th of March. The second case was Bank of New York Mellon International Limited and Cine UK Limited and others. The first thing to point out there is that the defendant there is also a part of the Cineworld group of companies, as is the defendant, the defendants in the Trocadero case that we're talking about today. Now, the judgment was given by Master Dagnall, and that was handed down on the 22nd of April 2021. But the hearing of the matter was in fact heard on the 24th of November last year and several other dates afterwards. And it was in between circulating of the judgment that Commerce Real came out. So there is also a brief consideration of Commerce Real in Bank of New York and Mellon. And of course, whilst these are the two latest instalments, specifically in relation to COVID-19, one mustn't also forget that looming in the background is also Canary Wharf Group and European Medicines Agency back in 2019. So talking briefly about what happened in Commerce Real, and I will just try and be as brief as I can because each of these cases could in themselves justify a seminar. So this really is just a high-level overview of the issues discussed there. The defence put forward by the tenant in Commerce Real, there were four different arguments put forward. The first was that the claim brought by the landlord was premature by reason of the code of practice. Now, some of you may or may not be familiar that this is a code of practice that was introduced by the government in respect of guidance for landlords in respect of commercial leases. And this was published originally on the 19th of June 2020 and then subsequently updated on 6th of April of this year. And essentially what that code of practice required landlords to do was to negotiate with tenants and to try and come to some sort of voluntary arrangement between the parties to deal with issues of payment of rent. Now, in this case, that defence was dismissed. It wasn't given into too much detail, and it was raised again in the second case, which I'll come back to in a moment. But essentially, what the judge found there was that in fact, it wasn't the landlord who hadn't been trying to negotiate it. It was the tenant who wasn't negotiating. So therefore, he didn't think that the code of practice really applied and queried whether it was relevant at all. The second defence put forward was that by bringing the claim for a money judgment, the landlord was seeking to sidestep the restrictions put in place by the government, by one, on the restrictions on forfeiture, two, restriction on insolvency proceedings, and three, the restrictions on commercial recovery of rent arrears and the statutory procedure there. Again, the judge dismissed that, saying that the defendant had conflated the difference between limitations on enforcement of the landlord's rights versus the landlord's right to obtain a judgment of sums contractually entitled or due under the lease. The third limb of the tenant's defence was that, properly construed, that well, originally put, it was that the landlord had failed to obtain insurance cover. However, it turned out during proceedings that the landlord had obtained insurance cover, and so therefore the tenant tried nimbly to alter their argument at the hearing and say, in fact, that properly construed, because the tenant had contributed towards the rent costs, that the landlord first had to claim on the insurance and was precluded from bringing a claim against the tenants. Alternatively, that the lease should be implied, or there should be a term implied as such to give a similar effect. The judge held that, one, the lease properly construed didn't have that effect, and secondly, that the defendants hadn't even put forward an implied term that they were seeking to imply into the lease, and therefore felt that it hadn't, it ought not to be implied into the lease. Finally, the defendants tried to argue that the dispute ought to be referred to an independent expert, but again, in circumstances where the tenant had already provided a defence and accepted the court's jurisdiction, that argument was not put very forcefully, and the judge rejected it. Now, in the second case, this was a much more detailed judgment, and it runs to some 99 pages for those of you who want to go off and read it. However, there are 7 main defences put forward by the tenants in this case. One, that summary judgment was an unsuitable procedure given the complexity and need for commercial background. The judge dismissed that, finding that summary judgment was a appropriate procedure for dealing with the issues, given the limited nature of the factual dispute, and that really this was a matter of law that needed deciding. It was better that it be decided sooner rather than later. Again, the tenant tried to argue, tried to argue that the matter ought to be adjourned by reason of the code of practice, and that the landlord hadn't taken steps to try and negotiate with the tenant sums for repayment of the rent. In this matter, the judge went into far more detail and essentially held that it was a voluntary code of practice. So even if the landlord hadn't tried to engage, it wouldn't have been relevant and it wouldn't have been appropriate for the matter to be adjourned. I pause briefly here and bring it back to Trocadero and note that before judgment was given, the tenants again in Trocadero had also applied to set aside, to adjourn proceedings on the basis of the code of practice, and secondly, the new proposed bill in relation to that commercial rent due as a result of coronavirus, which has set out different provisions that the government are seeking to introduce to help landlords and tenants come to agreement, which I'll discuss briefly in a moment. Again, both in Trocadero and in Bank of New York Mellon, the judge dismissed an application to adjourn proceedings. Thirdly, the rent cessor clauses should be construed so that they were triggered by the COVID-19 lockdowns, and secondly, implied terms that had the same effect. Essentially, the judge concluded that they couldn't be construed in such a way, and nor should terms be implied to give that effect. Fifthly, that the landlord had to recover under the insurance, again because the tenants had made contributions. The judge found that this was a somewhat circular argument and found that it had no real substance to it. And finally, frustration was argued, although not as in depth as it might otherwise have been, because the tenant who had tried arguing it had later settled with the landlord, and so it wasn't fully argued by counsel at the hearing as it might have been. So briefly talking about the commercial rent coronavirus bill, which I've just mentioned, this may be something that not everyone is aware of, but the government is now seeking to introduce a new process by which disputes between landlords and tenants can resolve disputes between them as a result of rent not being paid arising from coronavirus. Now, giving a brief overview, it's proposed to come into effect on March 2022. It sets out to prohibit steps a landlord can take to recover what's called prohibited rent debt. and it applies to any business tenancy that was adversely affected by closure requirements between 21st of March 2020 and 18th of July 2021. Now, these terms are all defined within the bill itself, and I'd urge anyone to go and read it. But a business tenancy is essentially any tenancy to which Part 2 of the Landlord and Tenant Act 1954 applies. Now, this is the more controversial aspect, in that the powers that an arbitrator may have in trying to decide these issues. It may write off the whole or any part of the rent debt that accrued during the relevant period. It may give time to allow the whole or any part of the rent to be paid up to a period of 24 months. Further, it may reduce any interest payable, including down to zero. And it will be up to the arbitrator to decide. It seems that the maximum period is likely to be 24 months, and that also during that period, the moratorium on a landlord's ability to seek forfeiture and insolvency proceedings will also continue until that 24-month period has expired. So what it does mean is that arguments about should another landlord seek to bring a claim for unpaid rent arrears, what one might say that a prospective tenant has firmer ground to seek an adjournment until this statute comes into force, because it's likely to substantially alter the rights of the parties in respect of rent that was due during the relevant period. I finish simply by saying that both Trocadero and the Bank of New York cases have been given permission for appeal and are due to be heard at the Court of Appeal, we think early next year. So as a slight caveat, that everything Chris and I say may say from here on in could all change in due course. But on that note, I hand back to Chris to talk about the first issue in the case.
Thanks very much, Nicholas. Yes, and I think with the cases going on appeal, I've heard one or two people express surprise that they've gone on appeal. Ultimately, these are summary judgments, but I do wonder if part of the reasoning for them going on appeal is the public importance, although the coronavirus bill may take that away moving forward. But certainly the points that we're going to concentrate on, the failure of basis argument and the implied terms, which you can see from the slide there are two of the three main issues in the case, are, I think, of more general importance and application. And I'm going to deal with the failure of basis. And of course, we're taking the case as the basis of our discussion this morning from the perspective of a lease and the property aspects of that. But ultimately, the lease is a contract, and therefore what is said applies to all forms of contracts, really. So the first question really is, what is failure of basis, which is the defence that was put forward. So moving on to the next slide, there's a rather wordy definition there from Chitty. In the judgment itself, the judge has relied upon a passage from Goff and Jones. I merely highlight that. I'm not just going to read it out. I confess, I should say, that I always struggle sometimes with the wording and language in Goff and Jones and the language of restitution. It deserves a second reading sometimes, but ultimately, failure of basis is what those of us who've been around for longer than we would care to remember were introduced to as failure of consideration. It's as simple as that. So the reason that it's moved on to a failure of basis as the label is simply to avoid confusion. Those of you who did law degrees, those of you who did conversion courses will probably remember the inordinate amount of time you spent in your degree or conversion course or howsoever you studied law, dealing with the issue of consideration and the adequacy of consideration, only to get into practice and realize that all those weeks spent studying it from an academic basis were fairly pointless, because issues of consideration very rarely arise in terms of whether there's sufficiency of consideration. They can arise, but it's pretty rare. But the failure of basis is to distinguish from that aspect of strict contractual law, which is whether there's adequacy of consideration. This is not about adequacy of consideration. It's not the promise which is referred to as the consideration, but the performance of the promise in the context of restitutionary claims. And an important point, I think, in relation to the failure of basis, just moving on to the next slide, is it's not confined to the contract. So an important point is from the Supreme Court's decision in Barnes and EastEnders Cash and Carry. I say it's from a point confirmed in that case, that a failure of a state of affairs on which the agreement was premised could be the failure of basis. And then you can begin to see now how the fact that the cinemas could not open because of the coronavirus pandemic and the regulations being nothing to do with the landlord or the tenant within the four walls of the lease, the contract, is then of relevance, because as it's a restitutionary claim, the cases identify it is different from defences in contract and tort, and therefore a failure of a state of affairs on which the agreement was premised is relevant. And in essence, what the defendants, it can be distilled down to this, what the defendants argued in this case is that what they bargained for was the use of the premises as a cinema, and that was the state of affairs on which the leases were premised, and that failed because they could not use those premises as a cinema during the coronavirus pandemic. I'm going mad. During the pandemic. So that, in a nub, is what it was all about. Now, it is well established that the failure of consideration or the failure of basis must be total. But we have here a lease of 35 years. So the question arises as to whether one can have a failure of basis of a divisible part. I'll come back to that. I just wanted to plant that seed in your minds. Now, there is no doubt that the relationship between contracts and the failure of basis is difficult. And in Barnes, Lord Toulson referred to the fact that most contracts are entered into with intentions or expectations which may not be fulfilled. But he also referred to the fact that the allocation of the risk of their non-fulfillment is a function of the contract. And therefore he emphasized that the failure of basis must be fundamental to the basis of the contract. But there is no doubt that if you've got a subsisting contract and someone, as in this instance, is trying to argue a restitutionary claim, there is clear and obvious tension. And you'll see on the screen there, Goff and Jones say, or the authors of Goff and Jones say, where there is a contract between the parties relating to the benefit transferred, no claim in unjust enrichment will generally lie where the contract is subsisting. And I think this is an example of a brave attempt to run failure of basis, which may yet succeed on appeal, but where there is a highlighting of the tension where there is a subsisting contract. So there are, however, exceptions. Now, what I can't really do is say to you, these are a list of the exceptions, because everything has to be dealt with on a fact-by-fact case. But at the bottom there's mention of Dargamo Holdings and Avonwick Holdings Limited 2021. That was actually a decision of the Court of Appeal, where the judgment was handed down a week after argument of the summary judgment application in the London Trocadero case, no doubt much to the tenants' frustration. That is a case which deals with the relationship between contracts and failure of basis. I haven't got the time to go into the detail, but moving on to the next slide, I think as an overview, Lady Justice Carr referred to failure of basis being a gap-filling device, which was complementary to the law of contract. And what she meant, and what Mr. Voss, sitting as a deputy in our case, refers to as the gap-filling, is that a claim in unjust enrichment should not firstly be inconsistent with the terms of the contract, nor must it interfere with the contractual allocation of risk between the parties. Now, I'd suggest to you that that probably doesn't leave a lot. It doesn't leave room for many arguments of failure of basis, but the court was very clear to identify that those facts of themselves do not mean that a failure of basis argument cannot be run in a contractual situation. As I say, ultimately, it's going to be very fact specific. Now, often with concepts, it's they can get lost. So let's move on to the next slide and look at the facts in this particular case. Well, the leases, as I highlighted earlier, contain an express statement of what is a usual principle, as the property lawyers amongst you will know, that the landlord gives no warranties as to the use of the premises. So what were the landlord's arguments? The landlord saying, well, there's no failure of basis in this instance. The first was simply to say that the grant of a lease is the grant of a term of years, or put another way, it is the grant of a legal interest in the premises. A term of years being obviously recognised as a legal interest in the Law of Property Act. So what was said by the landlord is that's the fundamental basis, not used as a cinema, but the grant of a legal interest in the premises. And in fact, one of the examples given was to use an old frustration case, which has to be taken slightly carefully because it was before panel opina and other cases where frustration of leases was recognised as a possibility, albeit a difficult one as well. And in Cripple Wood, where Lord Goddard said, in the case of a lease, the foundation of the agreement is that the landlord parts with his interest in the demised premises for a term of years, which thereupon becomes vested in the tenant in return for rent. So long as the interest remains in the tenant, there is no frustration though particular use may be prevented. And the landlord said, well, it's the same here. They've still got their legal interest, so therefore there's no failure of basis. A related argument that they ran was as to why there was no failure of basis is that the failure must be total, and putting aside the issue of severability, the tenant had possession throughout and received that part of the benefit. So the key question then became whether the benefit received by the payer, the tenant, was part of the main benefit which the tenant had bargained for. And the landlord relied on a number of cases which will be familiar to property lawyers, but which I needn't go through in detail now, where the essence of those cases is that the rent is an incident of the proprietary reversion and remains payable even where the tenant cannot use the premises for the intended purpose. The classic example is the case, or those cases where properties were destroyed during the war, but that was no defense to the tenant's requirement to pay rent. However, the judge didn't decide the case on that basis. I'll come back to that because I think it's slightly controversial. What he said is that there was no failure of basis. And he said that was because the use of the premises as a cinema is not fundamental to the basis. So that was using Lord Towson's words from Barnes. And he said that the use of the cinema fell into that category of being an expectation which motivated the tenants to enter into the lease, but it was not the fundamental basis for the lease. And it's early in the morning, but you can see that we're dealing with quite nuanced concepts here. So why did he say it was an expectation and it wasn't fundamental to the lease? Well, I mentioned earlier that the Dragamo case was probably frustrating for the tenants, but that's ultimately how he decided it, because he said that the reasons why it wasn't the fundamental basis is because of the other terms in the lease. There were some circumstances identified in the lease where what should happen when it cannot be used were provided for. The obvious example is the insured risks, and that's likely to be the case with many leases. So the parties have specifically dealt with that, and therefore that gave an indication as to the allocation of risk between the parties. And as an aside, all of these tenants' cases with the pandemic, as a personal view, are dealing with a situation where effectively it's quite binary. The tenants are saying that the burden of the pandemic should not be on us, but the consequence of that is it all has to be on the landlord. But the judge looked at the various terms of the leases, and of the leases, yes, 94 and 2014. He also referred to the warranty, the fact that there wasn't a warranty. Expressly, it was stated that there's no warranty by the landlord that the tenant can use as a cinema, and therefore he said that also went to allocation of risk. So he looked at the terms of the contract, and he said there can't be a failure of basis in this case because it will interfere with the express terms of the lease, and it will also interfere with how the parties have allocated the risk. So precisely the points that Lady Justice Carr had identified in Dragamo. So the judge went on to say that if there had been a failure of basis, if he'd gone the other way, he would have found it to be total, because the fundamental basis of, I shouldn't use those words because of what's on the screen, but the key essence of the contract was to use as a cinema, and they couldn't help. He dismissed the old property cases because he said they predate the development of law on unjust enrichment. But he also says that they do indirectly support a conclusion that the default position is that in the case of a lease, an inability to use for the intended purpose is unlikely to constitute a failure of basis, as it may be relevant to the presumed allocation of risk. I myself think that that's something the Court of Appeal will look at, because I find dismissing them, saying that they predate the development of law on unjust enrichment, but also saying that they give a general indication as to the allocation of risk is inconsistent. But he said that there was no general rule and each case had to go on its facts. So on that basis, the landlord's claim failed. The tenant's claim failed. Now, I mentioned earlier the issue of severability. And if I go on to the next slide, the judge concluded in this case that there was no reason in principle why the periods during which the premises could not be used as a cinema should not be treated as a severable part of the leases and the rent apportioned accordingly. And he said, look at the suspension of rent due to the insured risk, that apportionment takes place there. I confess I have a slight difficulty with this. Perhaps it's being schooled on the break clauses, at least a situation where if a lease requires payment of rent in advance and there's a break midway through, dependent on the exact terms of the lease, one would expect to pay the full quarter's rent, not a portion. And I'm not quite sure where one takes the severability just to a period where the COVID regulations were applied. Why is that part of the rent payment severable? Taken to extreme, what happens if there's a burst water main right outside the London Trocadero, which means that they can't actually open and use the premises as a cinema for 2 days? Does the tenant turn around to the landlord and say, well, actually, I'm not going to pay rent for those 2 days because it's severable part because we couldn't use the premises as a cinema? I think that is quite interesting. Another point where I look forward to the Court of Appeal's musings. A final sentence is, in this claim, this argument, failure of basis, was used as a defence to the contractual claim. There was no counterclaim for or in restitution, but the judge said, and of course it was a summary judgment application, so this wasn't that important, but the judge said, no, the proper way of dealing with it is actually to bring a counterclaim for restitution. So if anybody out there is thinking, I might have a case where a failure of basis may be a possibility, you can't just use it as a defence. It should properly be in a counterclaim. So that's all I have to say on failure of basis. So over to Nicholas for implied terms.
Thank you, Chris. So turning to the tenant's other argument, that there ought to be implied terms, the tenant was proposing 2 different implied terms that meant they didn't have to pay the rent. The first was a quite narrow clause, which I put up on the slide there, that if the permitted use of the premises by the tenant under the leases were to become illegal, then the obligation to pay rent and service charges otherwise due thereunder would be suspended and cease to be payable for that period. They also suggested in the alternative a more broader term, which I've also put up on the screen, is that the sums due under the leases would only be payable in respect of periods during which the premises could be used for its intended purpose, a cinema with attendance at a level commensurate with that which the parties would have anticipated at the time that the 1994 lease and 2014 lease were entered into. Given the nature of the terms that were sought to be implied by the tenants, one can already guess the direction in which the judge might have been heading when he saw them. And in fact, this case is a good example of the application of the law following the case of Marks and Spencer plc and BNP Paribas Security Services 2016, which confirmed, is perhaps the best word to use, the strict application of the test for implying terms into a contract. And in fact, the judge placed particular reliance on the recent summary given by Lady Justice Carr in New Design Services Limited and in Reality PT Limited. And so it helps as a useful reminder as to, one, what the general principles are, and two, what the outcomes are likely to be, and the sort of terms which a party will want to be trying to imply into a contract if they want to be successful. So Lady Justice Carr set out 7 broad principles, and the judge repeated them verbatim in his judgment when dealing with this. So it's helpful to go through them now. But number 1, that the implied term must be necessary to give business efficacy to the contract and/or obvious on an objective basis. So, and secondly, that these are 2 distinct tests. So either the term needs to give business efficacy to the contract, or it needs to be obvious on an objective basis. But what Lady Justice Carr stated, and also as was said in the BMP case, that it's unlikely that both those tests will not be met in a case where a term will be successfully implied into a contract. Turning to the business efficacy test, that will only be met where, without the term, the contract would lack commercial or practical coherence. And that the obvious test will only be met where it is so obvious as it goes without saying. And it should be obvious that 1, what term is to be implied, and 2, what that term should be. Further, that a term will not be implied if it is inconsistent with an express term, and that when a judge is seeking to decide what term should be implied, it's not dependent on the actual intentions of the parties at the time they were contracting, and so evidence as to what was in the party's state of mind at the time they entered into the contract is unlikely to be critical here, but rather it's the intention of the reasonable person in the same position as the parties who were contracting at that time. So what in effect it could mean is that actually the objective person may have a different intention at the time of contracting than the parties actually had themselves, and that, but that is the relevant test that the court will apply. And finally, that when deciding whether or not a term ought to be implied, is to be assessed at the time of contracting and not taking into account events that have happened subsequently. Then there's a broader suggestion that the equity of suggested implied term is an essential but not sufficient precondition. And again, just a reiteration that the test is one based on necessity and not on reasonableness. Finally, Lady Justice Carr in New Design at paragraph 47, she makes clear that when one is implying a term, that this is distinct from the interpretation or construction of a contract. She stated that the implication of contractual terms involves a different and altogether more ambitious undertaking than the exercise of contractual interpretation. And this is a bit of a throwback to the discussion between Lord Neuberger and Lord Carnwath in BNP Paribas, where they were discussing what Lord Hoffman meant in the Belize case, and whether implication of terms is part of the broader construction of a contract, or whether it's a sequential process and that one must first construe the contract and then look to imply the term once one's already construed the effect. Here, Judge Voss followed Lady Justice Carr and in taking a strict sequential approach and saying, well, first I look to construe the term, construe the contract, and next I look to imply to see whether or not a term ought to be implied, having construed the contract. I raise that here in that in the earlier judgment of Bank of New York, the judge in that decision took a more of a broad approach when assessing both implication and construction of the implied term in the round, whereas here Judge Voss very clearly separated them out. Again, referring back to what Chris has already mentioned, the judge placed particular emphasis on how the contract had already allocated the risk of an event happening, and held at paragraph 34 that it was a matter for negotiation between the parties as to where the risk should lie, and that it's the contract itself gives the expression of what the parties agreed, and that under his interpretation of the contract or the leases, that the risk had clearly been allocated to the tenant here. And further, again, the judge relied on the general principle that, one, a landlord gives no warranty to the use of the premises, and Chris has already referenced the Cripple Wood case in his section, and the fact that at clause 5.5, the lease expressly stated again that no such warranty was given by the landlord. In those circumstances, therefore, and on the facts of the current case, what the judge held is that the fact that the risk lied with the tenant did not lead to the conclusion that the leases, that is the 1994 and 2014 leases, did not lack commercial or practical cohesion, and that it was not necessary to imply a term that in effect gave that contradicted what was expressly stated. And secondly, that it could not be said that the proposed terms were so obvious that they went without saying. And so I just highlight again that the terms that the tenants were seeking to impose, or rather imply, the very nature that they were quite wordy and quite clunky and relying on several contingent factors, is always going to mean that the tenant or the person putting forward the argument is going to be on the back foot when trying to say such terms are likely to be implied. I think it's really key to highlight that the terms need to be obvious to the parties, both at the time of contracting and also when trying to make arguments for a judge, that these are terms that obviously need to be implied in order for one, to make sense, or two, for practical cohesion. And so on that basis, the judge dismissed the defendant's arguments about implying terms. On that note, we now have some time for any questions which anyone may have from anything that either myself or Chris has raised. And as Chris has said, we'll do our very best to try and answer them if we can.
Please do use the chat function. I'm just going to ask a rhetorical question, having heard what Nicholas said about implied terms and the sort of reinforcement of the move on implied terms back toward how the law used to be. I wonder whether Lord Hoffman's decision, Privy Council decision in Attorney General of Belize and Belize Telecom will be described anywhere as a heresy at any point soon. I'll just put forward that as a suggestion. Also, while we're just waiting, and perhaps as a final thought on the failure of basis, because you've probably thought, well, Chris has told us lots of negatives about how difficult it all is. Just to give an example, actually, of where failure of basis was successful, and that was in the Barnes case that I mentioned. And that was where the claimant was a receiver and was appointed over the assets of a group of companies following an application by the Crown Prosecution Service. So the agreement that the receiver had with the Crown Prosecution Service was that the receiver would take their remuneration from the assets of the companies, but the orders appointing the receiver were actually set aside on appeal. The receiver had done work, but the matter actually went to the Supreme Court, as I mentioned, and the Supreme Court held there that the state of affairs, so again it was a state of affairs, so taking it out of the four walls of the contract, was which was fundamental to the agreement, was that the receiver will be able to draw its remuneration from the company's assets. But that had failed, and as a result, the receiver was entitled to restitution in the form of payment from the CPS directly, and that was in circumstances where there was an ongoing contract with the between the CPS and the receivers. So it can work. You may say to me, well, that's a bit of a fudge, but then it wouldn't be the first case that's ever been decided on that basis. So it's going to be difficult, but failure of basis is clearly something that we all should be familiar with and consider, even if it's unlikely in many circumstances to arise as a viable argument. So I think that's one of the things to learn from this decision. It doesn't look, unless Nicholas, you can tell me that I'm missing something, which I often do when it comes to technical things, that we've got any questions. So have you got any?
No, I was just going to say that if people wanted to, there is on Teams at the top a chat bubble, which you can click on, which takes you through to the chat bar if people were having difficulty. But if not, then it doesn't look like we have any questions.
I'm sure everybody is completely bamboozled by the notion of failure to basis and clear on the implied terms. But if there are no questions, then it just falls to me to say, as it says on the screen, thank you for listening. Thank you for choosing to spend probably your first or your second working hour with us this morning. We hope it's been of use. And we hope to be able to see you all in person. I would say it's nice to see everybody, but I can't actually see anyone. So that is the nature of dealing with webinars like this. But thank you very much for listening. Thank you for being with us. We hope it's of use, and we hope to see you soon. Thank you very much.
Thank you.